All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Monday, March 20th. We're on voting list number 15, and we are going to start off with the withdrawn unfavorable. So that's Senate Bill 745. The motion is for an unfavorable withdrawn. It's been seconded. Everyone's okay being recorded in the affirmative. Next, we'll go to Senate Bill 221, and that is Shamari. Shamari, take us away.
Senate Bill 221 allows a court official or prosecutor to request that a person that posts personal information remove it and not post it again. Upon receipt of notice, the offending person must remove the personal information within 72 hours. An official may bring an injunction or an action for damages. A custodian of record must deny inspection of a public record that includes personal information unless the official gives permission. There's an amendment that adds the governor, lieutenant governor, and former governor and lieutenant governor to the list of protected persons under the bill.
Just a minute. Oh, sorry. Can I borrow that? A motion for favorable. It's been seconded on the amendments. Senator Sinner, do you want to adopt the amendments so we can discuss the bill, or would you like to talk first? All right. So the amendment's been adopted, and Senator Sidner would like to speak. Good.
Thank you. I just want to say on the record that if we're going to go down this avenue, I think that this remedy should be available for everyone. I don't want to go down this road carving out specific government officials who have this ability. I think if we're going to do it, we need to ensure that it's available to all Marylanders.
I'd like to concur with Senator Sidnor. Look, there's no doubt about it. Bad behavior shouldn't be tolerated, but I would say that we need to be working more on education of respect of people, not necessarily shielding special class people.
Thank you, Mr. Chair. I hear my colleagues' concerns. I'll just say that I think this is an important bill for allowing our court officials to be able to shield their locations, because as we've seen people who would otherwise be bad players going after those who are entrusted in a position to be unbiased and reasonable in their application of the law and the consequences and penalties associated with those that violate them. And if we're not willing to protect them, I think that adds potentially an unleveraged balance in the favor of those who would otherwise not be doing good. So I think this is an important bill. I'll be proudly casting my vote in support of this, just because not every Marylander has people looking up their address to come and harass them or potentially do illegal things to them. So I'll leave it at that. Thank you.
Thank you, Mr. Chair. I totally agree with the opinions just expressed by Senator Folden. The judges, they're not politicians. The judges, this is a progress of being a lawyer. You grow in your practice of law, and at some point you consider aspiring to the bench. And if you get to the bench, it's a progression of a the private practice of law now become more public. But we're not talking about politicians here. I mean, all of us decided to run for office, and we knew when we did it what we're getting into. Judges are not politicians. Judges are lawyers enhanced to another level. And we have had experiences in the last couple of years of judges getting killed or attempts to kill judges. In the case in New Jersey, the assassin killed the judge's son, as I recall, when she was in the basement. And there was somebody who tried to kill Justice Kavanaugh. I mean, this is not something which is academic. This happens. We need to protect our judges. So I totally favor the bill.
Yeah, so I agree with what Senator West and Senator Folden said. It's not often that happens here, and the assassination attempt to which Senator West refers was in my legislative district and occurred during the day in an area where I take my kids to piano lessons. And I can't tell you how much of this roils a community to know that they have a neighbor who was almost killed by someone who came across this country for the sole purpose of murdering that justice. And not only, as Senator West said, did they not sign up for it? We're the politicians, we signed up for it. But even if it's arguable that they did as federal judges or state judges, their families did not. The wife of that justice did not sign up for this. The two daughters of that justice did not sign up for this. And to have them live in fear and terror at all times is not something that we can abide. So I've been thinking a lot about this bill. I'm empathetic with those who oppose it for the very reasons that you oppose it. I thought it's been expressed very eloquently on the other side. But as I've spoken to the affected family and more so to the families along that street and in that neighborhood, I can see how much this has impacted their lives in a really profound way. So, and so that's why I'm supporting the bill.
I just want to make certain that I'm being clear. Not once did I say I don't support people's ability to hide their information. I'm all about privacy. What I am saying is I don't think that we should be making tiered or giving tiered remedies. I support a piece of legislation that protects everyone that you all just said you want protected. I mean, let's talk about doctors who provide abortions. They get attacked. Are they going to be next? Police officers. I know you talk about that, Senator McFolden, all the time. Who's going to be next? Why should this remedy just be available for certain officials? Why not make it available for everyone? I mean, if you all can give me an argument as to why it shouldn't be available to everyone, I'd love to hear it, because I don't think there's a good argument.
And hearing what you're saying, would a more feasible approach to this be set up a process where those who feel that they are in danger, et cetera, can apply for this, which is probably easier to administrate to do anyway. Some automatically maybe would go on, but they can apply and cut it, I mean, how many people are going to go through that in terms of applying for that, and what would it mean? But would that be a more feasible way of feeling of making the public feel as though everyone's important, anyone can apply, and here's a way to do it? That's just an opinion, an offer as a way of hearing what both sides are saying and saying it all makes sense and both make sense. How do we pull that together so that citizens will say, oh, gee, I'm not mad at him because he gets something I don't get. That's what they say about us anyway, right? Where they get this, I don't get this. But if it's streamlined enough to know that you're not going to be inundated with just crazy, requests that can be stopped at a certain point, then they feel like there's an open process. I feel like I'm in jeopardy because just like those who apply for guns, they, different reasons that they do it, but it's not over, it's not a process that will stress or break any system. Maybe that would be a better amendment to do that and look at it that way. I'm not sure, but I just put it out there.
And I agree with what you're saying there, Senator Sidnor. So I don't want you to think that I'm disagreeing. I'm not being disagreeable. And then hearing Senator Muse, we've already got the framework of language that we just threw out for good and substantial. So, there's an idea for the future legislation to present a good and substantial reason why you should have your information shielded. Leave it at that. Thank you.
I heard Senator Sidnor's comments with interest, and I would be perfectly willing to consider something which would afford the protections to ordinary citizens who feel endangered, but that's another bill. And in this case, we're just talking about a very limited number of people. Senator Sidnor's bill would apply to everybody in the state of Maryland. I think we should consider that separately. There may be reasons why it's difficult to protect everybody in the state. And so I'd be happy to take a look at it next year and seriously consider it. I have no disposition to be against it. But it's something that we ought to consider more deliberately than simply adding it as an amendment to this bill.
I'm not sure of those. Sorry.
You know, the reason why I ask is because there may be that outlet already with the address, the current address confidentiality program and the requirements of that. Yeah, but we'll find out the requirements. But again, that's a separate piece of legislation. Go ahead. There's been a motion, it's been seconded. I just want to make sure everyone has a chance to weigh in. We adopted the amendment. Okay. So we'll run it on the favor. We'll see where we go.
Vice Chair Wildstriker,
Yes.
Senator Sidnor,
No.
Senator West,
Yes.
Senator Muse,
Pass.
Senator Folden,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator, she said yes, right?
Senator Folden, or sorry,
Senator.
Senator Muse.
I'll take two votes. I get to.
Senator Muse. Yes,
You don't want that.
Chairman Smith,
Yes. With amendment passes 7-2. All right, let's go to Senate Bill 226.
Senate Bill 226 prohibits the person from knowingly or intentionally accessing with the intent to view child pornography as described in statute. An individual who is charged with violating this prohibition has access to existing affirmative defenses for the existing offense and is subject to existing penalty provisions for that offense.
I didn't know it was gonna be that fast. All right. Discussion? Sure.
Sorry. So I had some concerns about this bill the last time we brought it up, and I have spoken with the advocates over the weekend, and I feel really comfortable. My concerns were addressed. So I appreciate the committee for giving me a little time to get up to speed on the issues that have been before the committee over the last couple of years. So with that, I appreciate the time.
Just a question, how did we deal with the issue of sexting? Excuse me? It is addressed?
Statute that protects youth. Those definitions were created in a sexting statute protecting youth.
Okay, so this wouldn't impact that.
No, sir.
That would stand independently.
Correct. sir.
Okay, thanks.
Yeah, I'll ask counsel this. When did we pass this? Okay, sexting is a mitigating factor in certain proceedings. So in this, there's a definition of sexting. And then it says what it does not include. So it does not include conduct described in paragraph 1 of the subsection. So the sender is more than 4 years older than the recipient is more than 4 years older than the sender. The child did not consent to committing the conduct constituting the violation, or the child was coerced, threatened, intimidated in committing the conduct constituting a violation. And then there are mitigating factors it is a mitigating factor in a proceeding against a child under this subsection. Okay. Chris, I can send this to you if you want to see it. Do you still want to see it?
No.
Okay.
I listened to you.
Okay, got it. Charles, you want it? Senator McKay.
I think that was from last time.
Okay, got it. So wait, we had a
Move the bill with a second and a third.
okay. Streaming definition. We know what streaming means.
Well, it's accessing.
It's accessing. Yeah.
So just that's the.
And it would not, and you're very clear that this doesn't, like the mother that's checking in to like see what their child is looking at would not constitute accessing.
No, because it's not purpose.
We stayed away from the prurient intent language.
To open it and to access it. So in looking at the public defenders, they say, while this committee aimed in previous legislative sessions to fix the issues that were highlighted in NRA SK, the legislation passed by the General Assembly in 2021 can and does lead to the same disastrous results. Teenagers charged with distribution, possession, and production of child pornography for sending or receiving images of themselves engaged in consensual sexual behavior. The well-intentioned legislation that was enacted in 2021, House Bill 180, left too much to the discretion of police, prosecutors, and judges, the same discretion that led to charging, prosecuting, and convicting 16-year-old SK. The legislature, in passing a bill that continued to define adolescent sexting as child pornography, codified the very harm highlighted in NRA SK, endorsing prosecution for sexting with the criminal laws related to child pornography. So I'm trying to understand, was it addressed or was it not addressed?
So the definition of knowing is provided for in 11208 of the criminal law article. And that means that they would have to have knowledge of the character and content of the matter. Intentionally isn't defined in that part of the law, but just the model jury instructions, just an example of proving intent. Intent is a voluntary and knowing commission of an act that the law forbids. The defendant must have done the act consciously and voluntarily and not carelessly or accidentally. I don't know if that answers your question though about if it is intentional, but so they know what they're looking at.
To your definition, when you mentioned knowing, you said you have to know that it's child pornography that you're about to receive then?
Or access. So you're
so you know. All right,
you're
well, if
aware
that's the
of
case, then I'm
you're aware
probably
of the knowledge is means having knowledge of the character and content of the matter. So
I know what I'm about to get, not what I'm opening.
right.
All right, then I'm fine then. If that's the case, I'm fine.
You're late. I understand you're on the pornography bill. And I caught the tail end of the conversation. I apologize. Senator was talking about it. So this wouldn't apply to someone who just gets one of those hoax links and clicks the link, and then all of a sudden all the stuff pops up that's they may not have known or intended. Well, unfortunately, knowingly is going to come out at trial. That's not going to stop them from being arrested, raided, and put in the detention center. I'm just asking, if you don't mind, what is the current penalty and how does this change the current?
Right. So there's
Other bill.
so violators are guilty of a misdemeanor, 5 year, up to 5 years and up to $2,500 for a first offense. Subsequent offenses are felonies punishable by up to 10 years and or $10,000.
Sorry, break it down for me in the elementary terms. The current law is, and this law does. My computer's taking forever to pull up.
If you go to page 2.
Oh, it's here?
Yeah, it's not in their packet. It's just on the bill.
My computer's just getting pulled up. Okay, I got it.
Okay. So the prohibition would read, it places the language in the existing prohibition
I
on
got it.
possession. So it would provide, and I'm looking at the bill, page 2, beginning at line 5, a person may not knowingly possess and intentionally retain, or, and this is the new language, knowingly or intentionally access with intent to view a film, videotape, photograph, or other visual representation showing an actual child or a computer generated image that is indistinguishable from an actual and identifiable child under the age of 16 engaged in specified conduct. And the penalties are, so first offender would be guilty of a misdemeanor. For that first offense, it's up to 5 years, up to $2,500 or both. For second or subsequent, it's a felony, and offenders are subject to 10 years imprisonment and or $10,000 fine.
I think, I mean, do your will. I'm not trying to, like I always say, I'm not trying to persuade anyone else. I just believe that the current law, knowingly possess and intentionally retain, is reasonable. That's the whole issue, that you should know it. And then, you know, if you do click on something and you discover, oh no, this is porn, I didn't even realize, or child, whatever horrible thing it is that you didn't plan on, it really ought to be intentionally retain, intentionally access. Intentionally access? That's, I don't think that's good language. Intentionally access with the intent to view. How do you know what's, I'm assuming if you click a link, then you intend to view it.
No, you don't know. I mean, you don't necessarily know what you're going to view, but I mean, I think that it's the streaming, because you're neither retaining or possessing something that you're streaming. It's a weird thing. I don't know how you capture that up. You know, this is the best hack that they had at it, but I don't really know how you capture the streaming
What about
more elegantly than this, but go ahead.
knowingly access with the intent to view? Just knowingly or intentionally access, to me, is not tight language. I would think it should be something like knowingly access or intentionally access. There should be an act beyond the accessing that results in a crime. But you don't know what somebody does when they just click a link. I'm just saying it should be intent to retain, or I think intentionally retain, like. Can we say stream? The reason I say that is, I think if you say stream, when you say view, the word view to me says, oh, I clicked it and I viewed it. To me, it doesn't have to be a film. It could be a picture.
I see what you're saying, and you're right. I would not want anyone to tighten the language so that no one is hauled into court. Because once you are, it doesn't matter if you're exonerated in court. That stuff is on the internet. It ruins lives. So we're getting close, I think, to the language that says if they come after you, they're coming after you because they know you've done something, not something that will end up in court. And you go through the whole process, you lose your job, you lose everything, only to be exonerated. Then you have nothing to go back to. How do we tighten the language so that we know that when they go after someone who's clicked something, that it wasn't just a mistake? It wasn't some, I mean, what I hear is getting closer to what that language should be. I'm just not satisfied with what it is now, that somebody won't be caught up in this and a life ruined because of it.
Thank you. And I'll say my concern that I had on Friday has now been addressed, but in listening to Senator Carter, I'm wondering if the language that we have, this language, if it's about streaming, then this language is about the person who receives the stream, not necessarily about the streamer. And if I'm reading this correct. because the streamer isn't necessarily accessing it with an intent to view. They're streaming, right?
What about knowingly access, possess, and intentionally view? Not intent to view, but actually intentionally view. I think I'm struggling with intent to view. We don't know what, where does language come from? Is it taken from someplace else?
So I believe it was intended to mirror the federal law, which also includes accessing. And Senator Sidnor, I think to your point, actually, maybe I'm confusing who asked the question. So the streamer is covered under this, but the person who's transmitting the stream would be covered under 11207, which prohibits somebody from knowingly promoting, advertising, soliciting, or distributing those visual representations.
When we last considered this, I suggested adding the words with prurient intent there. Was that? Nobody like? We didn't want that. Okay, well, that would certainly protect a parent who.
Supreme Court said the standard is, but bottom line is, because it is children, I can live without that, because there should be no reason that you're doing it. The issue is it's got to be clear in this law, in this language, that it's not a quick hit and then you move on, but it's somehow detected that you access pornography and you can still be arrested for it. It really has to be more than, a hot second.
Like you knowingly or intentionally access or intend to view a film, videotape.
Is from when they click on something. You only know what their intent is when they actually take an act in furtherance of. So in furtherance of would mean that you then intentionally view or stream, not intent to view. You can't.
Doesn't prove intent.
There's
Intent to view. Again, you have to have an act in furtherance, a step in furtherance, not just an access with an intent. I mean,
Yeah. So I'm looking at the jury instructions. So you were instructed that intent is an essential element of this crime. Okay, here's the instruction. Intent is a state of mind. Intent is a voluntary and knowing commission of an act that the law forbids. The defendant must have done the act consciously and voluntarily and not carelessly or accidentally. Intent is a state of mind and ordinarily cannot be proved directly because there is no way to look directly into the person's mind, but you may infer the defendant's intent from the surrounding circumstances. You should consider all of the facts and circumstances in evidence bearing on the defendant's state of mind. In this regard, you may consider any statement made and act done or omitted by the defendant, and so on. So
an email comes in and says, come check out these underage children. That's clearly would provide, I prosecute them under that.
Look at Charles Sidnor in this video. And you all have seen that, right? Where you see someone's name or, whatever. I never click them. In the abundance of caution, I never click anything. But I want to be clear, and I'm not going to keep belaboring this. Most of the time, it's knowingly, not knowingly or intentionally, it's knowingly and intentionally. But aside from that point, again, access with intent to view does not imply it's been viewed. That's the point. It should say knowingly access, possess, access and or possess with and intentionally view. You have to have an act, something that is done to indicate an intent to view beyond the accessing of it, is my point.
So I'd spoken with Joyce King on Friday, and I guess was asking a similar question about possession, because it would sort of seem that when somebody streams, even momentarily, the material would be possessed on like whatever device they were using to stream the material. So wouldn't they be guilty of possession? And she advised that in these particular cases, you don't have the fruits of the crime when they actually find the person who was streaming, because the file itself is not actually stored locally on their device. Just evidence of that it was watched is. So it's never actually possessed on the watcher's computer.
I'm good with knowingly and intentionally adding access along with, access or possess or intentionally retain. I'm good with that. But the only part I'm struggling with, and I think that you could fix it, would be intentionally view, knowingly intentionally view. It's not with intent to view.
Go, but we'll pick up on this bill when we come back. Okay?